need to do some, we talked about the need to do some revisions to our rules. And so we have two proposals for you to consider today. And I'm going to walk through what the rulemaking process looks like, how you're going to give feedback and how others can give feedback, and what our timeline will be. And then we just have some updates for you, including an annual meeting reminder and some general business updates. So if you could go to the next one, Sarah. So first, we'll do our welcome. So as you know, FDAB consists of 24 members appointed by the governor and confirmed by the Senate. And our membership is in statute, it says that we have to have 6 school administrators, 6 contract teachers, 6 school board members, and 6 non-affiliated members. We had just had 2 new members who were appointed and confirmed. Laura Latham is with us today. Welcome, Laura. Thank you for being here on such short notice. We appreciate it. And Laura, I have in my mind middle school teacher. Is that correct? Okay. Do you want to come off mute and tell folks where you're from, where you teach, and what your subjects are?
Yes. Hi, everybody. My name is Laura Latham. I am a 6th grade language arts and social studies teacher in the Phoenix Talent School District, which is a small school district next to Medford, Oregon, and Southern Oregon.
Thank you, Laura. It's really nice to have you on the board. And then we also have Sasha McKeon, who is one of our new non-affiliated members. Sasha is a community college instructor at Blue Mountain Community College. And so good to have 2 new people on the board. Next slide, Sarah. So just a reminder, ODE provides administrative support for the Fair Dismissal Appeal Boards, which means we're providing administrative support and we're providing the support necessary to actually run the hearings. So we line up the court reporter, we get the room, we make sure everyone has copies of exhibits. The Department of Justice provides legal counsel to the board. They present at panel hearings, they provide all services that normally require legal training. And we have 2 new-ish faces. Lisa, who some of you will recognize because Lisa previously advised FDAB. So some of you may have worked with her, and Noah, who is new to us, but we've been working together for a few months, so doesn't really feel all that new anymore. Lisa and Noah, would you mind coming off mute and giving a little bit of an introduction of yourself?
Sure, I can start. Hi, everyone. I'm Lisa Umscheid. I'm one of the Assistant Attorneys General at DOJ, and we function, as Emily said, as your legal counsel and also as sort of staff support for providing services that kind of require legal training. So we help during the hearings by helping the panel decide how to rule on motions and providing that sort of assistance. As Emily said, I had this assignment before. I advised FDAB in the 2012 to 2016 timeframe, and then I went over to sit as a board member myself on the Employment Relations Board, and when my time there came to an end, I came back here to DOJ, and so I came back in November and am returned to this assignment. I'm happy to work with all of you.
Thanks, Lisa.
And I'm Noah Ellenberg. I've been with DOJ for about 7 years now. And as Emily mentioned, I'm relatively new to the FDAB work, but I've been enjoying it greatly so far. It's been good to work with you all so far. So thanks for having me.
Thanks, Noah. Next slide, please, Sarah. Okay, so let's jump into our rulemaking conversation. So the FDAB adopts administrative rules, and those administrative rules are in OAR Chapter 586. And we will send a copy of this slide deck out after the meeting so that you have it and can access the links that are in there. The rules include some rules that govern how the FDAB operates as a board, and there are some rules that govern how FDAB conducts hearings. Agencies and boards are required to review their existing administrative rules about every 5 years. So as part of that, we did a review of our rules to see if there were any updates that needed to be made. In order to amend an existing rule or adopt a new rule, we have to follow procedures outlined in the Oregon's Administrative Procedures Act, the administrative rules adopted by the Secretary of State, and FDAB's own rules relating to rulemaking. And that's part of the role that ODE provides with support from DOJ, is we take care of making sure those requirements are met, and we do all of the required filings. Next slide, Sarah. Thanks. This slide will look familiar to you from last October. This is an overview of the process and the timeline that we're going to follow. So the first thing is we have in May and June, ODE and DOJ did a review of the existing rules and developed some suggestions for you to consider. In June, we drafted our proposed revisions and we circulated those to you for your review before this meeting. In July, that's now, we're meeting to hear the proposed changes, and this is your first opportunity to provide feedback, but this is not your only opportunity to provide feedback. One of the most important part of administrative rulemaking is notice and opportunity for comment. This is a process that extends over time. It starts by giving official notice that an agency or board is considering a new rule or a revision to an existing rule. And then there is a period of time where the rule has to be open for public comment before it can be adopted and made final. So August 1st is when that official notice and opportunity for comment period would open. We follow the Secretary of State and FDAB rules. We file a notice of rulemaking with the Secretary of State. We file that by the end of July, and it would be published in the bulletin August 1st. And the bulletin is a document that the Secretary of State publishes and is made available statewide. And that is all the rulemaking that is being proposed by agencies and boards across the state of Oregon. So that's the official first step. It includes a copy of the draft rule proposals and a statement of need for the revisions. We post it to Secretary of State, it goes out in the bulletin. We send an email to legislators, letting them know that we're considering this rulemaking. And we send an email we notify interested persons. So how we determine interested persons, we post on our FDAB website, and we send an email to the ODE general listserv. That's how we make that available. So that's how we accomplish notice. And then the process, okay, so sorry, I'm jumping ahead of my own timeline. August 1st is when that first notice comment opens. August through October, the rule is open for comment. Members of the public, FDAB, anyone can send in comment about the proposed revisions, and we would consider that. Then we come back together in October, and that's when we would present to you a final proposed draft for you to adopt. And in that presentation, we would include all of the comment that we received and our recommendation for whether we should incorporate any of the changes suggested by commenters. And then FDAB takes a vote. If the rule is adopted, then ODE works to implement that rule, making any changes to websites or internal documents or procedures. So that's the general timeline. Public comment. We accept public comment in a number of ways. We have the FDAB email address. Anyone can send comment in through that email address. And we would also hold a rulemaking hearing. And that's just a virtual hearing that we would publish on our website. That we let people know, for example, on August 25th, we're going to hold a rulemaking hearing at 1 o'clock in the afternoon, and anyone can attend and provide testimony on the proposed rules. We would give you guys notice of that hearing, and you could attend if you would like. I will tell you that rulemaking hearings are not very well attended. We don't often get testimony through the rulemaking hearings. It usually comes in written testimony through our email, but we do that, and you would be welcome to attend if you would like. And I just want to be really clear that the rule language that you're going to be presented today is a first draft. This is a proposal that starts this process, and that rule language can be adjusted at any point up until final adoption. So this is the first step in our process together, and there's a lot of time over the next few months for you to provide input and think about what that rule language should be. Are there any questions about this process and timeline? Okay, we do it daily, so it feels really obvious to me, but I know that if it's not something you work with on the regular basis, it may seem confusing. So if any questions come up, feel free to reach out to me or Sarah. Okay, next slide, Sarah. Okay, so this is our first proposed rule revision, and this proposal is a recommendation from ODE. Your current rule requires you to hold an annual meeting on the 4th Monday of October at 9 a.m. We would like to amend the rule to simply require that you hold the annual meeting in October. This would allow us more flexibility to schedule the meeting and meet quorum requirements. As you saw earlier, this is a 24-member board. Our quorum, which is the number of members we need to have present in order to make a decision and take action, is 13. We currently have 15 active members, so it is really difficult to achieve quorum. Allowing flexibility on the actual date and start time will make it more likely for us to find a time that works for more members and to achieve quorum. So that's the first proposal. I was going to go through the two proposals and then have a discussion period. Would you like to do it that way, or would you like to have discussion after each proposal? Bob?
Let's do each one. I mean, I think this one's relatively easy and the other one may have a little bit more discussion.
Sure. Yeah, any comments or discussion on this proposal? Jim?
Hey there. So just to clarify, it also looks like since you're striking out at the State Department of Education, that would leave open the ability then to meet via Zoom or remotely rather than having to meet face-to-face by rule. So we wouldn't need an emergency executive order from the governor, for instance, to be able to meet remotely.
Yes, that's accurate. Thank you.
That's what I just wanted to confirm that. Thanks.
Yeah, Sammy. Oh, Sammy, you're muted. Okay, configure your mic, sure. And then Elaine, I saw your hand up.
Oh, my question was answered. I'm supportive. I think this is a logical change. Thanks.
Okay, great, thank you. Yeah, Sammy, if you want to go ahead and type your question in the chat, that would work as well.
Perfect. How about now? Can you hear me now?
Yes, thank you.
Yes, wonderful. So I think consistent with our experience today and also the intention of the initial language for people to know exactly when and where we meet, do we believe maybe the language having clarity on how the meeting will be publicized in terms of time and location or method of accessing the meeting, if it is virtual, can be stipulated in the rule itself. Maybe there are some other rules somewhere else about meetings that have that provision. I would recommend that we add that clarity so people, when they read that rule, they would know where to go and that they will have a heads up notice about the exact timing and dates within a certain grace period.
Okay, thanks for that. Any other comments? Okay, so I heard general support for it. I also heard from Sammy a desire to have more transparency for people who want to be able to learn about the FDAB, when and how to access the meeting. Okay, great. Okay, so then we'll move on to the second proposal. Oops. Okay, so this proposal is a suggestion that came out of discussions between the chair, Bob Sconce, the vice chair, Josh Wetzel, ODE and DOJ. And the goal is to provide more specific requirements for how jurisdictional questions are handled. When does FDAB have authority to accept an appeal, and what does that look like? So, for example, this is the discussion that it arose out of. So I'll give you the context. FDAB's authority with respect to charter school teachers is limited. Charter schools are public schools by definition, but the fair dismissal applies to charter schools only if agreed to by the sponsor and charter. So there's a statute, ORS 338115, and that says that statutes and rules that apply only to school districts do not apply to charter schools unless they are listed specifically in 338115 subsection 1, and FDAB is not listed in that, or are made applicable to the charter school through the charter agreement between the charter school and the sponsoring district. So FDAB does say, when in the language of the statute, that it applies to school districts. So this statute for charter schools tells us when FDAB would be applicable to a charter school teacher. So past practice has been that when an appeal by a charter school teacher comes in, and it's clear that the charter does not make the fair dismissal appeals law applicable to the charter school, the appeal is dismissed by the executive secretary. But this has been practice only, and it's not been clearly stated anywhere in rule or any sort of internal procedure manual. So the proposed revision would provide clear rule language on that question. Who makes the decision about jurisdictional questions? And the proposed revision says that the question of whether FDAB has authority to hear the appeal can only be made by the panel. So the executive secretary, when faced with a charter school teacher who the charter doesn't look like they apply to, the FDAB has not made, or excuse me, the charter has not made fair dismissal law applicable to that charter. This executive secretary would convene a panel and the question would go to the panel. This proposal will give ODE and FDAB better clarity on how to handle these jurisdictional issues. Noah drafted this proposed revision for us. Is there anything you'd like to add or explain why you chose to place the revision in this section, Noah?
Sure. So I agree with Emily. I think the overall goal of this is to make more clear that when an appeal comes in and that there are any issues about the board's jurisdiction, when we're doing the appeal, the panel is the one that gets to make that decision, not the executive secretary. And that would apply to all jurisdictional issues, but the overall intent was to make sure that the next time an appeal about this charter school issue comes up, the panel would make the choice. As far as the location of the rule, we looked at two possible rules. It was this one and 586-030-0025, which in part deals with preliminary motions challenging the board's jurisdiction. But because that rule is already specific to motions challenging the board's jurisdiction, and what we were trying to do here was add clarity to when the executive secretary spots a jurisdictional issue even without a motion, I thought the current rule placement was good, but we can certainly work with that if there's any concern.
Thanks, Noah. James, I see your question. Go ahead.
Thank you. I'm wondering, with this proposed rule revision, is there any conversation or potential opportunity for someone from our charters to be selected to participate on the panel, whether it's because a lot of charters have their own boards, a lot of charters have their own executive leadership team, administrators, and or teachers as well.
So are you asking whether, so when we convene a panel, the panel consists of a non-affiliated member, a school board member, and if it's a teacher that is filing the appeal, then one of our teacher members. Are you asking whether that teacher member could be a charter teacher?
I'm just wondering if there's an opportunity to expand the current membership if you are going to be including charters in this, because none of us actually are part of the charters. Even though, like, our school district, we sponsor 4 charters.
Mm-hmm.
So technically as an administrator, but I'm not necessarily one of our charter schools. Our charters actually have their own boards. They have their own administrators and their own staff as well. So I'm just wondering if this were to be a proposed rule revision, and let's say that we decide to adopt it, is there any thought about adding additional members or making folks that are a part of this appeals maybe members of the charter?
Yeah, thank you for that. I understand your question now. So the membership for FDAB is set by statute. So it's established by the legislature, and we as the Fair Dismissal Appeals Board do not have the authority to change that membership. The membership is contract for the teacher position is contract teacher. So I would have to look at the statute to see if a charter school teacher would be included in that, and I'll go ahead and do that. So I think the way I would if a charter school teacher can be a member of FDAB, which I believe they can, but I will confirm, the way we would handle that is in our conversations with the governor's office when we're talking about reappointment. We are having conversations about the diverse perspectives that are present on our board. And what does that look like? And so that's a conversation that I can have with the governor's office about the types of education entities that are represented on the board. Josh.
Yeah, so Noah or Lisa, I guess I have a question when it comes to this rule, because obviously we've had lots of discussions about this, the case in question and stuff, but is there any rule where the executive secretary can make a ruling on behalf of FDAB without FDAB, a panel being impaneled? Because I wonder if this would be a better rule if it was changed to the executive secretary shall select a panel to schedule hearings, and then decisions then are made by the panel itself, correct? Because it sounds like in this one that the executive secretary can still make some decisions, but this one is excluded, would now exclude jurisdictional issues.
Right, I think. Right, so sorry, yeah, the goal here, the way the current rules are set up, they do not clearly state when the executive secretary shall rule on jurisdictional issues or other motions. And that's what we're trying to clarify. I think it would be okay to say that the executive secretary shall not rule on any motions. I guess for Emily, are there any practical problems there with restricting the secretary's authority too much? Are there sort of non-substantive motions that the executive secretary is ever deciding on?
I would have to think about it. Off the top of my head as I sit here, I'm not thinking of any, but I could think about it.
I guess my question goes down to, because there's ODE and there's FDAB. ODE obviously supplies Emily, who does the administrative work of the panel and stuff, but any orders, denials, whatever, I mean, anything that comes from FDAB should have board member signatures on it, correct? And then that would come with an impaneled 3-person board.
That's what we're trying to do here. What I'm saying is that the current rules are not expressed one way or the other.
So and so that's my question. Would it be better placed if it was just the executive secretary shall select a panel, and then a sub rule being general orders, or orders on motions or whatever from FDAB will be issued by a panel?
I see Lisa's got your hand up. Do you want to chime in, Lisa?
Yeah, I would just offer that that sort of case handling and case processing. There are some decisions that are sort of just administrative. So, for example, from my time sitting on the Employment Relations Board, it would be not uncommon that people would file with the wrong board. Right, so an appeal would come in and it was filed. It was really something that should have, for example, gone to FDAB or should have gone to the Employment Appeals Board. So there's a certain category of decisions that you probably want to allow wide latitude for your administrator, which in this case is the executive secretary, to make. Otherwise, the volunteer board members are going to be called in to do a lot of work that really is, basic sort of administrative processing. Sometimes it's just obvious that something is not appropriate for a panel decision. So I would just advise the board, maybe caution the board a little bit to not be too constraining, because you may be creating quite a large workload for yourselves. And then once something's in the rules, of course, as Emily just explained, it's quite an undertaking to change the rules. So you just want to be a little bit thoughtful, I think, about how much you constrain the administrator of the board.
Absolutely. And that's so, and educate me then, because as I read the rule, the way I'm thinking about it is if all of one is satisfied, then it goes to two. Two would then trigger a panel to be impaneled if all the elements of one, A through E, are satisfied. So that way we know, yes, it went to the right place. Here's all the proper documentation. Now we can impanel a board.
But then what do you do about, I'm not following because I'm not sure, what do you do then when this situation arises where, the issue of this contract teacher example that Emily gave, charter school teacher example that Emily gave.
Well, and that's where I think that there's a look. I mean, so my understanding is everything was filed appropriately. A through E was filed appropriately in the case in question, and then a decision was made to deny it on jurisdictional grounds.
I think 1A through E are steps that I take once an appeal is filed. So that's directing the steps that I take. And then 2 starts when I convene the panel. Is that? I hear you saying it differently. I hear you saying I'm making sure.
So, yeah, so in 1, it says when an appeal is filed, the short notice, certified mail, practical electronic, the notice shall include. So yeah, if an appeal is filed,
a notice shall be sent by the executive secretary
to include that stuff. Okay,
yeah,
fair enough. So how do we, Lisa? Because in this case, there's 2 issues I think that kind of brought the nexus to this conversation. One, that the jurisdictional question wasn't necessarily answered, and 2, the board has no recourse to fix it in the decision already made. So how do you break out what can be decided before it gets to a board versus when it gets to a board? Because I get the nuanced stuff from the beginning, but in this one became very it became a bigger deal.
Yeah, so it's a good question. And the question, I think, relates to what you would put in your rules versus what you would the direction you would just give your administrator. So again, rules are, and there's various reasons to put things in rules. Sometimes it's for clarity. Sometimes it's for sort of institutional history. Sometimes it's to make it clear to the parties what will happen. And then there are other things that you don't need to put in a rule. You can just, instruct the executive secretary to handle things in a certain way because she's acting on behalf of the board, or he is acting on behalf of the board. So I hope that's some guidance. I don't have a particular point of view about which way this should be resolved. So I don't mean to be suggesting I have a point of view about this. Other than I do think it's prudent to be thoughtful about not so overly constraining what staff can do that volunteer board members essentially become staff through having to be involved in many more decisions than has traditionally been the case.
Yeah, fair enough. Thank you.
And then I saw Cameron, and then Tori, and then Sammy.
I'm thinking about this, about including the board more, but also not constricting, kind of like Lisa mentioned. What if we added in there that the executive secretary, along with the chair and vice chair, so that you bring in 2 board members as they're elected to kind of weed through. It's kind of a 3-person team as they come in to make the decision on whether they go to a board without constricting the executive secretary to not have anything. It would kind of put 3 people on notice and then move forward. So adding that piece of including the board chair and the vice chair to make those decisions moving forward.
Cameron, would you add that for this jurisdictional issue, or would you add that for all actions taken by the executive secretary, just so I understand?
So I would add it to number 2. It would say the executive secretary along with the board chair and vice chair must take steps to select a panel on a hearing, and so that it kind of becomes a team effort. Once section 1 has been satisfied, section 2 then brings in a 3-person team to weed through the next step.
My one response back to that would be then, for example, so we get it in, and the immediate steps that Sarah and I take are to reach out to legal counsel. Am I including board and vice chair on all of those communications? Like the 3 of us are doing, setting the hearing date, figuring out which members are going to be on the panel, how many days are involved. Like those are pretty administrative tasks.
So those would be administrative tasks, but I think it would kind of cover us when it starts coming down to jurisdictional rulings, and maybe something that we have not foreseen moving forward is having a couple board members active in the cases early on would, I think, help capture some of what has happened in this situation and the possibility for some others.
Okay, great. Thank you. Tori. And Lisa, I can't tell if your hand is up to response or if it's a legacy hand. It's a legacy hand. Okay, Tori, go ahead.
Thank you. I was wondering if there was an opportunity through an MOU or an OAR to require charters just to follow the same process of their sponsoring school district and bypass this whole new rule.
Yeah, so it's a statute that says that state law only applies to charters if it is listed specifically or made applicable through the charter. So any change to that would have to be made by the legislature. It can't be made by the Fair Dismissal Appeals Board.
Got it. Thanks.
Sammy.
Awesome. Thank you. First of all, I want to really acknowledge the intention behind the addition on the screen here. From my local experience, it provides a huge value for the complainants or appellants to know, oh, actually, I need to follow the process. And thank you for redirecting me to go through the right steps. I think that saves time. Sometimes that helps appellants to reach the right entity or jurisdiction within the time frame rather than waiting. So I really want to acknowledge the intention behind it. First thing I have a concern about is any accidental sentences like the one here. It gives me lots of pause, like, okay, it might be needed to be read a couple of times. We're having discussion now about the intention. So really, I am inclined to suggest that everything we see here, except in red, we push it to number 3, and then number 2 speaks directly to jurisdictional issues and lay out how we deal with the jurisdictional issues. Is it this executive secretary denying based on jurisdictional issues, or is it executive secretary redirecting the appellants based on jurisdictional issues, and the appellants may have recourse if they disagree. So really separating these two might be really beneficial for people to read. And I see the value of having the jurisdictional issue before the intention of the whole slide here, except in red, which is about creating a panel and how to do the work before we start the hearing. So now, in that regard, my suggestion or my concern here, and I'm drawing analogies with local school boards appeals and also appeal courts and judicial system, and I want to really lean on everybody's experience in terms of how our board might be a little bit different. When you have someone appealing on a case and there's a jurisdictional issue, it might be accepted and it's warranted. It might be denied and it's the denial is warranted, and it might be the other way around. So there's like 4 different possibilities here. And I want to be clear that we want to give expediency for the executive secretary to give response to the appellant. But also, is that a matter of communication and clarification, or is that a matter of final decision that there's no recourse behind it? And I wonder if we want to maybe just in line with what I know from school boards, considering a hearing, Supreme Courts consider to hear the case or not, is maybe the suggestion around having a representative of the board delegated to sign off. That's the denial based on jurisdictional issue is warranted. I think that might be beneficial, just to not put the burden on the executive secretary to make a final determination, but definitely empower them to have that conversation with the appellants that, hey, this is not the right place where you are right now. You might need to be going somewhere else. And we give them that response as soon as possible as informational rather than decision. So just to summarize my thoughts, separating their jurisdiction from the remainder of the slide here. The second thought is delineating what do we mean by jurisdictional issue in terms of denial or redirecting, and whether we want to delegate to a chair the sign off on that decision if there is a decision being made.
Okay, and I also hear like balancing the impact on the appellant who may need information more quickly in order to file in the appropriate venue if we are not the appropriate venue. Okay, thanks, Sammy.
Absolutely. Thank you.
Go ahead.
Yeah. I think I'm comfortable with kind of either route, either having a full panel look at it, the one that would then be taking the case if it actually moved forward, or they just deal with the jurisdictional piece. I'm also comfortable if whoever the chair and vice chair are at the time, or at least one of them being involved if something is going to get denied, or we're looking to see if there's a valid appeal or not with it.
Okay. Any other thoughts or comments?
Without raising my hand, I like the idea of having the executive secretary, the board and chair and the vice chair kind of helping triage cases as they come in, and then assign them out to a panel. Even if we settle jurisdictional issues, like in this case, you don't want to unduly prejudice a panel on jurisdictional issues if you just do a quick triage with the board chair, vice chair, like, hey, this is, yep, this is accepted, we accept this, or no, it's not, and here's why. But I think that there should definitely be a board member signature on any of the denials. For sure.
So I just want to make sure I'm tracking suggestions. So one thing I hear is, and I'm not sure this is what people are intending, so I'm going to state it. You tell me if I'm wrong. One thing I'm hearing is that we don't want the executive, we want the board and vice chair, or one or the other, involved with the executive secretary in every step that is currently set out in subsection 2. Another thing I hear, okay, I'm seeing head nods, okay. Another thing I hear is it is okay for the executive secretary to make some jurisdictional decisions. For example, dismiss a case if the charter doesn't specifically make the fair dismissal appeals law applicable to the charter, so long as the board chair and vice chair sign off on that. So I see Bob shaking his head no. So we do like the idea of sending jurisdictional issues to a panel.
A panel, I'm going to jump in. Sorry, Emily. A panel or the chair and vice chair, so that it kind of involves the board at that. So nothing is denied without at least the board chair or the vice chair involved before it's denied.
Okay, so then I'll kind of just push this practical question. What's the difference? Why not just convene a panel?
I was going off of some advice from Lisa about, the restrictions and some of that stuff. It's easier for you and Sarah to contact with the board chair than putting out a poll, finding dates with some other people. I think it's also we're now online, so finding dates is going to be much easier for people to have a quick meeting to get together for a half an hour discussion over jurisdictional question versus everybody running to Salem and having those kind of things. So keeping it with the board being involved at every step from 2 on, I think is really where we're coming from.
Okay, so I'm going to,
And if I may, I think if someone's stepping up or is elected as a board chair or vice chair, then they know the onus is on them to be available to do their role in part of the FDAP panel. So they should have that understanding that they're going to be a little bit more involved than waiting for an email potentially to sit on a panel later in the year type thing.
okay. Sarah, could you unshare for 1 minute? And then I'm going to share. Thank you. So does this reflect what I'm hearing? The executive secretary, board chair, and board vice chair shall take steps to select a panel and schedule the hearing in compliance with statutory timeframes. Does that reflect what you were asking for? And can you see the Word document that I have? Okay.
Yeah, we can't see it.
Sammy, go ahead.
I do. I want to reiterate my encouragement that we separate them to 2 different bullet points.
So Sammy, yours would be that the executive secretary takes care of these things that are highlighted.
Correct.
Other decisions are made by the executive secretary in conjunction with the board about when to, sorry, no, you're probably dying.
And I guess if I may, just go on Sammy's of separating them out, which I agree. Maybe there's a step 2 like you're doing, but the new step 2 would be the executive secretary, board chair, and vice chair will accept or deny a case. And 3, if an appeal is accepted, the executive secretary then shall in panel and do all the formal stuff.
Agreed.
Shall
Formally accept or deny an appeal.
Based on jurisdictional grounds. Am I right? As your suggestion, accept or deny an appeal based on jurisdictional grounds necessarily, or is there other grounds we want to keep it open?
And I want to be really clear that I'm just throwing this language up in an attempt to reflect back what I'm hearing, and that we would go back and have conversations about how to actually capture this. This is really just to reflect. This will not be the language. Go ahead, Lisa.
Yeah, I just get a little concerned about what would happen when we have a board chair and or a board vice chair that couldn't be reached, or we could not take the statutorily required steps within the required amount of time. So I'm wondering if a better approach would be kind of a more streamlined approach of what Sammy is suggesting, which is keeping number 2, the original revision, but then adding a new number 3 that would just say something along the lines of, when an appeal presents a jurisdictional issue, the executive secretary shall consult with the board chair and vice chair before issuing the notice, or something like that. That accomplishes, I think, what you're trying to do without making, I don't want to denigrate the work that's described in subsection 2, but it's a lot of back and forth between Sarah and counsel on the length of the hearing. It's really, it's not just the board chair is going to be having a conversation with Emily. It's going to be a lot of emails back and forth, because number 2 is really the administrative work of setting a hearing. So I just encourage maybe an approach a little more like this. I'm just making up the drafting here as I sit here, so it may not be the correct exact or the best wording, but maybe some concept a little more like this.
Cameron, go ahead.
I see us looking and trying to fix something from the past, but then we're also not necessarily thinking about the future. What if it's not a jurisdictional issue and there's something else that comes up? I kind of liked what we had before where there is a filter, and I agree with Josh, where if you are elected as the board chair and vice chair, you kind of need to make yourself a little more available so that we don't get bottled down and miss timelines and things like that. So I kind of liked the version before where we had the two that had the people kind of make a decision, a go or no go, and then allowing the staff to have the jurisdiction to set the panel or set the days and times and things like that. But if you are chair or vice chair, you should be kind of on top of your emails and things like that.
Josh.
Correct. And I think even in this case, because the case in question was from my school district that I was a board member on, so I couldn't hear it. So in having the conversation, I would have to abstain, but that would still mean that the executive secretary, the board chair, and the vice chair, even as abstaining, which is an action, could still make that decision.
Sammy threw in the chat that it's or designee, if you throw that in there, if there is a conflict.
That's a good idea.
Yeah, and probably I would suggest in line with that, and sorry if I'm jumping to my the row here, but giving one elected official, one board designee, which is the chair or designee, I think should be sufficient rather than having a panel of two, chair and vice chair. And that way, even if the chair is busy, they can designate someone, preferably more senior with experience, who could rule on these things. So that would be my suggestion for discussion, whether we do it chair and vice chair or designee.
I was leaning towards 3 people so that there was a tie-breaking vote on there. So it could be chair, vice chair, or designee along with the executive secretary so that it allows for a tie-breaking vote.
Any other thoughts?
No, I agree with that. I would just put the designee would follow the same position as the board chair. So if the board chair is a teacher, then the designee would have to be a teacher. That way it still follows that same line, but I like that. And I don't know if you'd even put the jurisdictional issue, this might be one of them, but I think any denial should be denied by the board. It shouldn't be denied by the executive secretary. So whether it's a jurisdictional issue or if it's formally being denied, it should be formally being denied through this process. So I don't know if you even have to add the including when appeal presents a jurisdictional issue.
Okay. Lisa.
Yeah, just another consideration maybe to think about is that this board, like some other boards that the state has, is made up of a balance of different constituencies, which are not always aligned. So school board representatives may have one point of view about what type of an appeal, would be should be processed out on an administrative or ministerial basis, whereas one of the contract teachers might have a different point of view and one of the unaffiliated members might have a different point of view. So I just raised that you're introducing into your rules a sort of authority for certain positions when those positions weren't necessarily reflective of all of the constituencies on the board. That may matter or it may not, just raising that as a consideration.
Whereas when we send those decisions to a panel, the panel is constructed to include the various constituencies. Got it. Thank you, Lisa. Go ahead, Cameron.
And our chair and vice chair rotate. So I think that it also lends itself to having different groups because of how our rules are around chairs and vice chairs. So we will have half of our groups represented in those decisions.
Any other thoughts?
Sorry if I'm new, so I just wanted to ask a question.
No, chime in, Laura.
Is there anything that's stopping the executive secretary from convening a panel that includes the chair and vice chair?
So when we convene a panel, the statute says that we have to convene a specific panel. So if it's an appeal by a teacher, it has to be a non-affiliated member, a school board member, and a teacher. If it's an appeal by an administrator, it's a non-affiliated, a school board member, and an administrator. So we have specific requirements for what that panel looks like.
And so it could include the chair and vice chair as long as they fall into those constituencies.
Correct.
Thanks.
Yeah, I want to just emphasize something Lisa said with a different spin on it. The current FDAP statutes talk about when an appeal is received, both the executive secretary being involved and then the panel being involved. So I would just recommend getting some quick legal advice from us before creating a new 3-member panel, different from the original panel, that is going to vet all appeals that FDAP receives. And I'm not saying it can't be done, I'm just saying that's something I would highlight for some legal advice.
I agree. Yeah, sort of where I was headed was I don't feel so we did not schedule a vote today. There was going to be a discussion and then we move on to filing. My feeling is that we do not have solid agreement or consensus around what this language would look like. We don't have enough members here to take a vote. So my proposal would be that we take this feedback, we consult with, we asked DOJ to do some legal research on the issue NOAA identified, and then we come back with proposed language for the board to vote on that would be filed with the Secretary of State. Does anybody have any comments or thoughts on that plan? Bob?
So I don't have a problem with having it looked at. If there is an issue, it would be nice if we could have a couple of options based upon the discussion that try to meet those needs as much as possible, so that we're not doing all the language changes necessarily, but looking at these couple of options would work. Which do you like better? Which seems to fit with what the guidance has been?
That sounds like a good plan. I agree. No,
I think there's good, sorry, I think there's good kind of intent behind what we're looking for. So I think we can come up with a good proposal. One question while we're researching, I guess, when it comes down to this is the legal question: does the executive secretary have the authority to deny an appeal? Because if that's, depending on the answer to that, could erase, I guess, or change the intent of what we're trying to get to.
okay, great. Noah, go ahead.
Yeah, I just want to understand the overarching policy goals here. It sounds like the idea is we want the panel to be deciding some cases with jurisdictional issues, but not other cases with jurisdictional issues. And we want the executive secretary to be guided in that decision by the chair and vice chair, whether that's by a 2-to-1 vote or by just consulting and still leaving the decision with the executive secretary. Do I have all that? Is there any strong disagreement to just what the policy goals are? What the end result?
I think the policy goal is that if the appeals are filed to FDAP, then FDAP should be denying the appeals. An actual panels. There should be a appointed FDAP member signature on the denials. So whether jurisdictional issues or whatever, otherwise, it's just in this particular case that brought up this discussion was based on jurisdiction.
Okay,
But we've now gone farther than that, right? I mean, now. I mean, would the board generally be okay with a rule that just says that any denials of an appeal must be voted on by a panel?
I'm sorry, can you say it one more time? Your mic was.
Something along the lines of any denial of an appeal shall be done only by vote of a panel.
Personally, I think that would work because if it's accepted, it's going to go to a panel anyway. If it's denied, it should go to a panel. So either way, a panel is going to see it before FDAP speaks to it. So but in this case, or I guess in any case, if Emily denies an appeal with her signature, then perception could be ODE canceled my appeal, not FDAP.
Sure, and I think the way we got to where we are right now is because there was concern that requiring a panel to deny any appeal might give the panel additional burdens in resolving really easy appeals.
And this is where I guess ODE and the panel may be in conflict based on the makeup of FDAP versus the makeup of ODE.
I don't understand what the conflict is.
Well, in this case, in my opinion, an improper decision was made that led to a due process, someone not getting due process that should have gotten it, in my opinion. But in a panel, a board never heard about it. It never went beyond the executive secretary.
So I guess what I'm not understanding though is if we have all decisions, whether to accept or deny an appeal, so a dismissal of appeal can only be made by a panel, what is the conflict or what is the problem there?
I don't see a problem with that. I don't see a problem with that at all. If because then a panel decides in a denial, and then eventually a panel will hear the acceptance.
Mm-hmm.
That's not an issue. So the language, yes, this is where we're at. I'm just saying the perceptions, and then Noah provided the counter argument. And so ODE and FDAP may not be in alignment when it comes to a denial. That's why I think it's important if FDAP's going to speak, FDAP needs to speak.
Yeah, Noah.
Yeah, so I think my question for the board is it okay to just amend the rules to say something along the lines of all denials by a panel, all denials of an appeal shall be made by a panel? Or do we need to go farther and also add the chair and vice chair either formally or informally to the process of whether to accept or deny an appeal or not? I'm just trying to gauge where people are policy-wise to help us inform the drafting of the rules and the research.
It looks like Sammy's got a response, and then Cameron. Go ahead.
Absolutely. Maybe framing, not necessarily a response to the question Noah provided. I think I can imagine 3 possibilities here. Possibility 1, an expedient informational response to the complainants is needed and warranted so they can move to the right jurisdiction, and the complainants will agree with that information and will move on to somewhere else. I think that is one possibility or scenario that we might need to stipulate rules about. Number 2, formal determination and notice on very clear grounds that this is not the jurisdiction for FDAP to hear it, and consistent with the board considering, school board considering not to hear a complaint, or Supreme Court, one justice saying we're not going to hear this. I think that would be a possible denial that could happen by a chair to sign off on it. And then the third layer or level, it is when a panel is warranted to really delve into whether to hear the complaint or not. So maybe I'm trying to frame the question that Noah provided. There might be 3 layers that we need to answer it according to each layer. Is it very clear cut and the complainants will agree with it? Is it a formal response that's an expedient response from chair, vice chair designee need to provide, or is it a situation where the panel will require?
You know, one thing, and then I'll let you go, Cameron, this is, it may be that some of the questions that you've raised, Sammy, and some of the issues can be handled with a policy manual as well. So you have a certain level of information in the rule, but you don't want your rules to be so specific that you are mired down and can't move. So you can have rule provide one level of authority and clarity, and then you can come in with a policy manual that provides more specificity about how you handle specific scenarios. And so that's something in consultation, and we can come up with something like that as well. But that's what I was thinking about with your comments, Sammy. Go ahead, Cameron.
No, I think to answer your question, I would love to see both kind of proposed as you move forward. Like what would it look like if we had the kind of set filter of a small board with the executive secretary, and then what else would it what would it look like if we had just a line that said all denials are to be done through a board? I think about timelines and stuff, and if we're throwing a board together to deny, we may be running into some timeline issues. And so I kind of like the idea that we have a set group of people that will kind of pre-filter all cases coming through. But I'd be curious to hear other people's feedback. And so if we could have both of those as kind of options for the feedback as we move forward, I think that would be great.
Okay. So it feels like we have a path forward. We're going to step back. We're going to take another run at this, do some more research, and come back to you with a few proposed drafts to consider at a future date. We will have to do a vote at that meeting, which means we will need 13 members present. So Sarah will be working really hard to get 13 people there. So please do your best to accommodate. We'll try and aim for just an hour. I think will probably be sufficient, which might be easier to schedule. This may bump back our adoption depending on when we could get it scheduled, because our opportunities to file the notice, the Secretary of State publishes the bulletin, which kicks off the official notice and opportunity for comment period at the first of each month. So if we can get this done by the end of July, we would be in that August bulletin. If we can't get it scheduled by the end of July, we will have to do it at the end of August, and we will be in the September bulletin. You have to have about 52 days from the time when you publish in the Secretary of State bulletin until a rule can be adopted. That's the comment period. And so we will need to make sure that if the time has not run by the time we have our October meeting, we will schedule an additional short meeting to do the actual vote to adopt the rule. So I just want to make everybody clear of that timeline adjustment that we might need to make. Go ahead, Bob.
Do you want to separate the yearly FDAB meeting from the other one, or are you going to keep them tied together?
I would recommend keeping them tied together because it creates more administrative work to do the filings, but I can move forward if somebody has a preference that we move forward with the annual date one. But it would be easier on the work side to keep them tied together.
Okay.
Any objections to keeping them tied together and moving the two rule proposals on the same schedule?
I don't.
Okay.
We're still a year out from it taking effect on the next one. We've already got our others scheduled.
Mm-hmm.
So.
Okay. Great. Okay, so then we'll bring this part of the discussion to a close, and I'll move on. Sarah, if you wouldn't mind sharing the slides again to the last section, which are a few reminders. So we have our annual meeting in October. The next meeting, we had scheduled for Tuesday, October 24th at 9 a.m., but that's not the fourth Monday of the month because we thought we'd have our rule amended. So we might need to revisit that date because we won't have the rule amended by then. Stay tuned on that, folks, but it will be in October and we'll keep you up to date. At the annual meeting, the FDAB selects the vice chair. The vice chair will serve as the chair the following year. and the vice chair position rotates in order of teacher, board member, non-affiliated member, and administrator. So this year we will be looking for a vice chair from the non-affiliated member category. And then Josh, who is our current vice chair, will assume the role of chair during this annual meeting. And we will thank Bob for his service. And we'll meet virtually and we'll live stream to the FDAB YouTube account. We might make a change to that, Sarah, and we might just make it a YouTube. We might make it a Zoom link that people can join publicly, because we were having trouble with the YouTube. So we'll stay in connection about that to make sure we meet our public records obligations. Okay, next slide. Training. All FDAB members are required to complete annual training on preventing discrimination and harassment and information insecurity. The training has to be done through your Workday account, and this has presented some challenges for members. Sarah will be reaching out to you to make sure you have your training assigned to you in Workday and that you're getting that done. It has to be done by the end of the calendar year. One of the things that we have arranged for you, and our ODE help desk is being incredibly generous, a lot of people are having trouble with the multi-factor authentication. And so our ODE help desk has offered to help anyone who is having trouble accessing Workday. And so if you are having trouble accessing Workday, reach out to Sarah, and Sarah will connect you with help desk to get that figured out. As I mentioned, reappointment, we are continuing to work with the governor's office to build our membership. The next round of confirmations will be in September, and I've communicated to the governor's office our difficulty meeting quorum. I've said we have enough people now to convene the panels that we need to convene, and the addition of Laura as another teacher member is a huge benefit, so thank you, Laura. But we do have a need for additional members, and that will make our quorum issues less of a problem. So continuing to work on that. Next slide, Sarah. And then final orders. This is one of the things we had talked about during our October meeting last year. Sarah has put all of the final orders on the ODE website. If there is no order linked, so if there's an appeal listed and no linked order, that means that the appeal was withdrawn or dismissed. We thought about not posting on the website the appeals that were dismissed, but what we quickly discovered is that people call and ask, well, where is this number? Because they're numbered in order. And so if 003 is missing from the page, people get confused and call. So we went ahead and listed all of the cases and are linking the cases that have a final order. So that's available. And then we will send out these slides to you so that you can access all of the links and you have this information. And then I think, oh, go ahead, Bob.
How far do they go back? I only see through 2012.
And then there's a list of cases that has 2008 to 2023. And also all of these cases and final orders have been sent to Willamette Law.
Yeah, and I should add, I should have said orders from a certain age forward are linked. One of the reasons we have not linked the old orders is we are under an order from the U.S. Department of Education Office of Civil Rights. Anything we post on the website has to be accessible to people who have limited sight. So it has to be able to be read by a screen reader. Our old orders are not accessible. And so what we do is if somebody requests an order that is older, we go through the public records process, but we can't post it to our website. Did you have another question, Bob, or is it a legacy?
It might be good to double check. I think where they're supposed to be, and it's not there. The stuff from 2008. And
the link I have in the slide deck is the link to the page where they're posted. So
okay, I'll try off of that.
You'll be able to access that. Yeah. Okay, Sammy, go ahead.
Yeah, thank you very much. I really appreciate the work you're doing there. Question that I have, and really the intention behind it is to minimize any FOIA requests that might add a burden to you in the future. Do you feel, well, here's my first question. When you dismiss an appeal, do we provide a rationale or reason or ORS section why it's been dismissed? And I see a thumbs up. So my follow-up question would be, is it beneficial for FDAB to publish dismissed based on such and such So it minimizes people reaching out and asking, can I have the details of those cases, etc. I want to know why. At least it gives a little bit of transparency why we're dismissing some cases and we're hearing some others.
Yeah, that's a great point, and we'll take that into consideration when we're thinking about how to best present that information on the website. Most of the appeals that are listed and don't have a linked order were withdrawn by the parties. So the parties reach out to us, they've reached a settlement and they've withdrawn the appeal.
Yeah, absolutely, and I agree. I think the point is just only for the dismissed ones.
Yeah.
And they're
And Sarah
very
and I
few,
were
as you
having all
mentioned.
kinds of conversations around how do you best present this information on the website so that it's clear and it cuts down on the most questions. Yeah, thank you. Okay, then that's the end of our planned meeting. Are there any questions or comments before we close for the day?
I'd just like to add real fast, Emily and Sarah and Lisa and Noah, thank you for coming and doing the work on behalf of FDAP.
Thank you. Okay. Oh, thank you, Elaine. Okay, then we will go ahead and close. Be on the lookout for communication from Sarah to set our next meeting. And please get your training done. And I would encourage you to start your training early, because then if you hit any snags, we have the ability to get it done. We did not meet our training requirements last year because we had so many problems with Workday. So we're really trying to, I did call the governor's office. We don't go to training jail, but I'm trying to make sure we meet that training goal requirement this year. So thank you. All right, Sarah will send the slide deck out. Thanks for your time, everyone.